Thornhill, and I am a family law attorney here in Florida, and I have been practicing for nearly 20 years, and I'm here today to discuss with you Florida timeshare law. We used to use the terminology of custody, but now we say timesharing, because what's important is how much time is the child or children going to be spending with mom? How much time is the child going to be spending with dad? Let me also say that it's not just time, it's actually overnights. How many overnights in the year is the children going to spend with one parent versus the other parent? Majority is just really set up for how much time more than the other parent that the parent has with the child. So if you look at Florida Statutes Section 61.13, in subsection 3, there are several factors, A through T. And those factors the judge takes into consideration to determine how much time or overnights each parent should have. Those are very, very important. It's the first thing that I talk about when I meet with a client to discuss how much time they want versus how much time the other parent should have. Which parent is going to honor the schedule and be reasonable when changes are required? Well, that's very, very important, because the judge can write down and put in an order who's going to spend this overnight with the child and who's going to have this holiday and who's going to have this birthday and who's going to have Wednesdays. However, there's always going to be something that comes up, and both parents need to be flexible. They also need to make sure that they're trying to honor that schedule as much as possible, with the understanding that you have to be flexible. When you go in and you're in front of the judge, you want to be able to argue to the judge that I'm the parent that is going to keep with the schedule, and that I'm also the parent who's going to be flexible when changes need to be made. So if one parent works, is in law enforcement and works 2 days on and 2 days off and every other weekend, but they're arguing for week on and week off with the child, judge has to take into consideration where are the children going to be when the child or when the parent is working. So is it going to be with a new girlfriend, a new boyfriend? Is the child going to be with grandma and grandpa? Is the child going to have to go into daycare the entire time? So what's important also, when you're asking for 50-50 with my child, or I'm asking for all of this time with my child, you have to remember and think about, well, what is your work schedule? And who's going to be watching the child when you're at work? Because the judge wants to know that if you're going to be saying, I want to take care of my child and that I'm going to be caring for him or her, that you're actually able to care for him or her. Are you going to put your child first, or are you going to put what you want first? I want more time with my child because I don't want to pay child support. Or I want more time with my child because I don't want the other spouse to have time with the child. Well, those are your needs and not your child's needs. Are you saying that I can provide better for the child, that I have more space for the child, the child will have his own room at my house? Because those are important needs for your child. Or are you saying, I just want more time with my child because I don't want the other parent to have time with the child? Judges really look forward to hearing information when you're in front of them with what exactly is the reason you're wanting more time. The length of time that a child has been with one parent is important. If mom and dad live together, and the child is now 7 years old. And then one parent moved out, and the child stayed with the parent that stayed in the home. And now it's about 3 years before you get to court. The judge is going to want to know, well, what have you guys been doing for the past 3 years? One parent had more time with the other than the other, or is it been 1 week with mom and 1 week with dad? Because if we're now 3 years later and everything has been going fine, and whatever parenting schedule the two parents have worked out is working, then most likely the judges are not going to change what has already been working, unless there's a reason why it was working. Sometimes I'll have a case where a parent will come in and say, yes, we have been doing this for 3 years because it's taken us this long to get to court. However, the only reason that we're doing that is because the other parent won't agree to change anything, fights me whenever I say, hey, I want to change this a little bit around, or hey, this is not working for the child. The child's not getting his homework done on the nights that he or she is with you. So why can't we do this schedule versus that schedule? And we need to bring that up to the judge and let the judge know that, yes, we have been doing this for the past 3 years, but it's not working. Well, if the parents live an hour away from each other, but one parent lives 10 minutes to the child's school, then the question is, well, should the parent that lives further away from school have the child on nights where in the morning the child has to get to school? Because the child now has to sit in the car for an hour, get up earlier, get ready earlier, get to school earlier. So judges will take into consideration how close mom and dad are and how close they are to the child's school. Normally, when parents go in front of the judge, they're going to go in with a good moral fitness. The judges want to believe that both parents are morally fit to be parents, and that's why they're there in court. That's normally an easy one. It's such an odd factor, and normally doesn't come into consideration because normally both parents are mentally well, physically healthy, and can take care of their children. Of course, there are circumstances where that might change. If your child's in school, if both parents know where the child goes to school, the name of the school, the name of the teachers, how their academic performance is, name of the doctor, name of the pediatrician, goes to all of the pediatric appointments, versus one parent doing everything, the court is more likely to let the parent that does all of that continue to do all of it. Sometimes in parenting roles, one parent does more than the other, and that's okay, and courts understand that. But you want to make sure that if you're the parent that is doing all of it, that you're not excluding the other parent from that information. Make sure you're letting the other parent know, hey, little Johnny has a doctor's appointment next Tuesday. If you're going to be able to go, that would be great. Or, hey, our kid's going in for braces this Tuesday, and we need to know, are you going to be able to be at the appointment? Because, the orthodontist wants to talk to both of us. You need to make sure you're including the other parent rather than excluding them. Now, keep in mind, though, that in Florida, courts normally do not allow children to choose which parent they want to live with. There's a little variation because if you have a 2-year-old You can pick up your 2-year-old, put the 2-year-old in the car seat, and buckle them up, wave to them, and say goodbye to them because they have to go and visit with the other parent. However, you can't really do that when you have a 16-year-old. You can't pick them up and put them in the car and buckle them in and tell them to go, because the 16-year-old is probably going to get out and not want to go. If you have a 16-year-old, courts are more likely to let 16-year-olds, 17-year-olds, maybe even 15-year-olds kind of decide that I just really don't want to go this weekend over to the other parents because we have prom this weekend. But as a parent, it's your responsibility to encourage the time sharing, encourage the schedule, and to encourage a relationship that is both beneficial for the child and for the other parent. When a client comes in, I always ask, walk me through the schedule of what you do with your child on the day, every day. What time do they wake up? Who makes breakfast? What shows do they watch? Who washes their clothes? Who makes them their meals? Who picks them up from school? Who takes them to school? I always ask, who are their friends? Do they have neighborhood friends? Do they have play dates? Those are things that you need to know. And if you don't know them, you need to find them out now. Now, it's absolutely fine if your child doesn't have a schedule, but you're somehow, some way, even though it may not be a traditional schedule, it's got to be some sort of schedule. You need to be able to show the judge that this is what we do. We go to the beach every weekend, or we always have a family meal on Sunday nights, but that's it. Otherwise, we're watching TV while we eat dinner, and that's fine too. But you need to be able to show that this is when I'm spending time with my child. That's why you need to make sure you let the other parent know, hey, we have a doctor's appointment next week. Or, oh, the child's sick, so he or she didn't go to school this morning, but everything's okay. You need to make sure that you're communicating with the other parent. I always ask that my clients communicate by text message or by email, so that way we have proof going into court that we're putting it out there, my client's putting it out there and letting the other parent know what's going on, even if the other parent isn't. If you have domestic violence between you and your spouse or you and the other parent, then that's definitely going to be a factor that is taken into consideration when it comes to a parenting plan. Because parents that can't get along, parents that have issues between them, whether it be sexual violence or domestic violence, physical abuse, anything like that, then the court then also has to consider, well, how are these parents going to exchange the child? Where would they be able to do it that is safe? Should they be exchanging the child at a police department? Should they be only doing exchanges at the school? Should we always provide that there's a third party present? Domestic violence is a huge factor that comes into time sharing. That's definitely a big factor. If you're not being truthful to the court, it kind of lets the court know that you're probably not going to be the parent that's going to be the one that they want the majority with, because it's important that you're very frank and honest and upfront and as transparent as can be with the court. Customarily, mom is the one who picked up the child and took the child to school, picked him up in the afternoon and brought him home. But now during this case, dad is the one who's doing it. Mom needs to be able to show that, yes, but dad is only doing it while this case is pending. And as soon as this case ends, he's going to go right back to letting mom do all of that. You need to be able to bring that up. So I normally say that whatever the parties were doing beforehand, before we started this litigation, keep what's going on. We don't want to change it. You'll see that a lot of the factors overlap, and that's okay, because there might be a little nuance that changes here, maybe a factor that you were going in one direction with can now go in a different direction, and so that's why these are very much of them overlap, and that's all right. To maintain an environment for the child that's free from substance abuse. I mean, I think that goes without saying. You don't want to say, well, as soon as we get done with court, little Johnny, you're going to be spending all of your time with mom, and mom's going to take care of you. You definitely don't want to bring your child into the litigation and let them know what's going on, because ideally, this should be something that both parents are deciding and can come to an agreement without court intervention. If the court does have to get involved, then the children don't need to know about that. As a parent, you know that there were needs of your child when he or she was 5, but now are different when he or she is 10 versus when they're 15. Cell phones are a big thing. So, maybe the 4-year-old doesn't need a cell phone, but the 12-year-old does need a cell phone in order to communicate with the other parent. So you need to make sure that you're meeting those child's needs and letting the judge know that. The last factor is kind of a catch-all. It's any other factor or any other relevant information that will help the court decide what's best for the child. And these are called the best interest factors. And that's what's important in Florida. Florida relies on these a lot. Every judge normally pulls out this statute, section 61.13, looks at these factors, gains this information, and this is what goes in the order. What's important in Florida is the initial determination of timesharing or custody is made based on the best interest factors. However, after you've got that initial judgment, after the judge says, okay, I've looked at all of the factors, this is what I'm ordering. If either parent, years later, months later, for any time that you need to go back a second time to court for a modification, the burden jumps from so low of the best interest factors, jumps really high to a substantial change in circumstance. So judges look again at the best interests, but they also look to, well, what's changed? Mom and dad are not getting along? That's not going to be enough. Well, one parent is in a better position, that's not enough. Several years ago, I had a case that was heartbreaking because when mom and dad got divorced, mom was living with her boyfriend. He was taking care of her, and she kind of got lost after the divorce. So dad got the majority of the time. He had the children all the time, and mom got the children every other weekend, Friday till Sunday night. And then a couple of years went by, and mom went to nursing school, and she bought a house. She had a full-time job. She was getting married, was very, very stable. And so she decided she wanted to go back to court and get majority time sharing. She wanted her kids full-time and to let dad have the kids every other weekend. And the courts came down and said, no, that's not enough, because your kids are doing fine. Dad's doing a great job, and it's great that you're doing so well, and it's great that mom is in a great place and has a head on her shoulders and has a good position, is owning her own home and is getting married, and it's great. But the thing is that your kids are fine. And so she could not modify the time-sharing schedule. So let me just remind you that it's important to get it right the first time.